have to repeat me. Thanks for coming out to OCS's first educational night. Sorry about the seating, but pull a seat up on the floor tonight, get comfortable, and we'll work on having chairs for Tuesday night. So if you guys want to have a seat, I'll introduce.
What's Tuesday?
Tuesday's Loring speaking on the Patriot Act and the fusion centers and all that kind of stuff. Post-Patriot Act, I should say. Guys, well, I'd like to introduce Bill. It's Newmiller, correct?
Bill Newmiller. Instead of the old Miller, it's the Newmiller.
Okay.
Yeah.
All right. He's going to talk to us tonight about the First Amendment and freedom rights and, you know, kind of interacting with the police. So I'm going to give him the stage.
Okay, thanks a lot. Thanks for having me tonight. It's a real pleasure to be here. My name is Bill Newmiller. In the full disclosure here, some of you may know, I don't know if anybody knows or not, I teach at the Air Force Academy. And so I always have to tell people, my views, believe me, don't represent the Air Force Academy or the Air Force or anybody in government. I'm here tonight speaking on behalf of the ACLU as a member of their Speakers Bureau. And it's something that means a great deal to me, and I appreciate the opportunity to talk about the First Amendment. I've got a few little things to hand out to you. I'm going to start out with this. It's just a bookmark sort of thing. Start passing it around a little bit. I hope there's enough to go around. Actually, it's good if there's not enough to go around because that means that there are more people here than I expected, which is a good thing. It's just a little bookmark that has the amendments that we consider being the Bill of Rights. I think, I know when I was in school, I was always taught it was the first 10 that were the Bill of Rights, but we include more than that in here. We include up to the 19th Amendment, 13th, 14th, 15th, and 19th Amendments, which expanded the rights of American citizens. And I'm going to primarily be talking about the First Amendment. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of people peaceably to assemble and to petition the government for a redress of grievances. And although the first clause, the Establishment Clause regarding religion and the exercise of religion does get a lot of play in our society, I'm not really going to talk about that part tonight. Instead, I'd like to talk about the rest of the amendment, particularly freedom of speech, freedom of assembly. And so that's the main thing that I want to talk about. I've always been interested in questions about freedom of speech and what speech is. Sometimes I teach public speaking. And I remember when I was a kid, I had an uncle who was a World War II vet. And I think like a lot of kids, I like to kind of, tap dance around the edge of authority. I was a good kid, but I would kind of like to prod a little bit, especially my elders. And he was a World War II vet, had fought in the Pacific, and he had some pretty strong opinions about people who burned flags, burned the American flag. And I asked him about that, and I was trying to push him a little bit. And I said, what if the flag is like just printed on a piece of paper? And he said, well, that's still a flag. It doesn't say it has to be cloth. That's still a flag. I said, well, we get the Chicago Tribune in my house. And back in those days, the Chicago Tribune, like a lot of newspapers back then, had the American flag published up here in the top of the newspaper, next to the name of the paper. And I said to him, well, we get the Chicago Tribune, and that's got the American flag published on it, in color even. And at the end of the day, my mother takes that paper that we've read and she wraps the garbage in it. and then we throw it in the trash. So is that desecrating the flag? And he said to me, oh, well, no, because your mother doesn't mean anything by that. And at that point, I realized that he was not objecting to the act, he was objecting to the symbolic nature of the act. That is, he was objecting to the part that had the meaning. It depended upon what it meant. And the courts have come to accept this idea of freedom of speech as being something that really is much broader than just what we manufacture with our vocal cords and our tongues, but it goes to include symbolic actions as well. And that makes sense. We have a lot of phrases that we use in our language that involve symbolic action. We say to people, actions speak louder than words. And so there is that element of communication that is involved in speech. And so speech really is much broader than just the words that we say. There's been an evolution of what this First Amendment means over the years. When we say the freedom of speech, and we talk about the right to peaceably assemble, however, we're not talking about absolute rights. There is some balance to those rights. The most common one that we hear people talk about, and we'll talk about its origin a little bit later, is the idea that we don't have the right to shout fire in a crowded theater, unless it's like actually on fire. Okay? If it's on fire, we don't have the right to do that. But this right of freedom of speech is one that has developed, particularly in the 20th century. There were very few court cases involving, Supreme Court cases involving freedom of speech until the 20th century comes along. And one of the most important ones in the early 20th century happened during World War I, and it involved a guy named Charles Schenck, Charles Schenck. And Charles Schenck was a secretary for the Communist Party, or the Socialist Party of America. And he was trying to get people to resist the draft during World War I. And so he was handing out literature, and he was mailing things to people, he was printing out stuff, and leaflets and so forth. They would say things like, do not submit to intimidation, assert your rights. If you do not assert and support your rights, you are helping to deny or disparage rights, which is the solemn duty of all citizens and residents of the United States to retain. So he's handing these out, and he ends up being arrested for doing that under what was called the Espionage Act of 1917. And this went to the Supreme Court. Now, it was in 1919 that the Supreme Court decided on his conviction. What do you think? Do you think that they affirmed his conviction, or do you think they reversed his conviction? Maybe somebody knows.
Upheld?
Hmm?
Upheld?
They upheld his conviction. They upheld his conviction. Yes?
Was the Alien and Sedition Act that John Adams signed, was that never challenged?
No, actually, it was not. It was not. That was one of the things that the courts never ruled on, much to Thomas Jefferson's displeasure. But in 1919, the opinion, it was a unanimous decision, and it was written by Oliver Wendell Holmes. And he said that it was constitutional. He said, when a nation is at war, many things that might be said in a time of peace are such a hindrance to its efforts that their utterance will not be endured so long as men fight, and that no court could regard them as protected by any constitutional right. So they upheld it, particularly during wartime. And there were a couple of other cases that came up, but the big landmark case where we see things changing happens in 1969. And this is, it was Brandenburg versus Ohio. And this involved a guy named Charles Brandenburg, who was a member of the Ku Klux Klan. And he was a leader in rural Ohio. He held a rally. And during that rally, you know, they're burning crosses and all that kind of stuff. During that rally, he made a speech claiming that our president, our Congress, our Supreme Court continues to suppress the white race, and announced a march to take place on the 4th of July, and said that it was a duty, a necessity to engage in crime, sabotage, violence, and so forth. Well, he was convicted. He was convicted of inciting violence. When the Supreme Court reviewed his case, they essentially reversed the earlier decision and expanded the right of freedom of speech. And they came up with a three-part test to determine whether or not the speech was constitutionally protected. And the three parts of that were intent, imminence, and likelihood. And first of all, by intent, it was clear that somebody was intending to promote the idea of violence. The second being that it was an imminent kind of violence. It wasn't conditional. It was, you're going to go out and let's do this right now. Let's take these rocks and start breaking windows now. And finally, likelihood. That is, not only would he be advocating violence, but there had to be a likelihood that people were going to respond that way. And so if there wasn't a likelihood that people were going to respond violently, then the speech would be protected under the Constitution. And that's the way things have remained since 1969. I mentioned that there are some limits on freedom of speech. We talked about the fire, shouting fire in the theater. Advocacy of illegal action is not protected. So if you advocate that people do something illegally and it meets those three things, okay, intent, and imminence and likelihood, then that is not protected. Fighting words are not protected. So, you know, if you're saying something to somebody and it's inciting them to anger, that's not protected speech.
Would hosting a website dedicated to promoting occupation be not protected because I'm advocating for something that might be considered illegal?
I don't think so. I don't think so. I think that would be a real stretch because you're advocating a political position, right?
Yes, but given the history of occupation and that it's an illegal act, people are illegally occupying something.
Well, whether they illegally are occupying something or not that's something that is not determined until somebody is actually convicted of occupying something, right?
Mm-hmm.
So I don't see, I'm not a lawyer, that's the other thing that I have to tell you in terms of full disclosure is I'm not a lawyer here. But when you post something on the web,
Mm-hmm.
I think it'd be very hard to say that you are dealing with something that is imminent or about which that there is likelihood that people are going to be responding that way.
It would meet those two needs?
What's that?
Did you say it would not meet those two?
I think it would. I don't think that it is either an imminent.
Oh, you don't think so?
I don't think it's imminent, and I don't think that it's likely.
Really?
Okay.
What about like in terms of Arab Spring?
In terms of what?
Arab Spring, that was extremely likely and then very extremely imminent based on a lot of social networking on the internet.
Also, I've just reposted plans for every Occupy to occupy all the ports on December 12th. And in Loveland, they're going to be occupying the Walmart distribution center.
That's not violent.
And that, but it's imminent and it's
But
illegal.
burning a flag is not
I
violent.
think that may run into another issue that we can that I'll talk about.
Mhm.
Okay, that deals with the forum for the forum for public assembly and speech.
Okay.
Okay. So, fighting words, the forums, which I want to mention. There are a number of different forums or classification of forums. A traditional public forum would be places like parks, public areas. Right? Public parks, sidewalks, areas that have been traditionally open to political speech and debate. Those are the areas in which speech is the most strongly protected. You have the greatest protections there. As we move away from those areas, speech is less protected. Sometimes you might have a public property that is open, but only, it's not a traditional forum, for example. It might just be open for a limited purpose. You might have designated or limited forums. So, for example, a school board meeting, they might reasonably have restrictions on what you can talk about at a school board meeting, like it might have to be school business.
Bach v. Westminster Mall, the Colorado Supreme Court upheld the right to protest inside the mall, but not inside the individual stores.
That's right, and I want to mention that because that's a significant expansion of the federal rights that we get from the Constitution, and that stems from the state Constitution.
Can you repeat that citation?
Bach v. Westminster Mall.
That's very interesting. We were just kicked out of the mall,
Yeah,
and we weren't
that
in
also-
specific stores.
It doesn't explicitly say it, but it gives you the right. If you want to hand literature to somebody going into Target or Walmart, that you can't do that because it's their customer. But once they're coming out, they've bought their whatever they came to buy, and now they're no longer their customer, and you can hand it to people coming out.
Yeah, and it gets into a related right, the right of assembly, for example, which gives you the right, for instance, to pick at a store, but not to keep customers away from the store. Finally, there is some public property that is not a forum at all. For example, public television broadcasters aren't subject to the forum analysis.
Propaganda machine.
Now, there's an interaction between a couple of amendments that's important to consider. And that's the interaction between the First Amendment and the 14th Amendment. The 14th Amendment didn't come about until after the Civil War. And there are several amendments that came into effect after the Civil War that involve equal protection. And that they didn't come into being until later in the 19th century is perhaps one of the reasons that we didn't see so many cases of Supreme Court cases dealing with the freedom of speech. The First Amendment dealt only with what the federal government could restrict, not what the states could restrict. And so what that meant was until the 14th Amendment was passed in 1868. The states could impose, states and local governments could impose any restrictions that they wanted to on public speaking. It was only the federal government that could not.
The 10th Amendment says that the states can't, I mean, it's actually outlined in the Constitution, they can't take away a right that's granted to people.
Well, that is true, and that's a, people call that the 10th Amendment argument, all right? But the interpretation of the 10th Amendment has not included this. When the 14th Amendment came out, the 14th Amendment reads, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of laws." And so when you get into that issue of equal protection, it becomes particularly germane. Yeah.
What about the NDAA that they just passed?
The what?
1867?
NDAA, National Defense Authorization Act, that it looks like it's going to be going through, and that
Yeah.
if we
What
shred
does that do?
amendment-
It's Bill 1867. It says that you can, without, that you can be, you can,
Oh, indefinitely.
Well, we
Yes.
already had the
Citizen
Patriot
without
Act
charge.
give the executive power to declare any American a domestic terrorist. Now what this does is allow citizens who are declared domestic terrorists to be apprehended, tried, and shipped off without habeas corpus. So where's the...
not even tried,
Where's the,
actually.
where's
They
the,
say-
where's the, where's the protection there?
Right.
Yeah, you don't even have to be tried under it, actually. They can
No.
hold, they can detain you without trial and without charges indefinitely.
Well, and people are being detained that way.
Why
Well,
are
and
people-
for American citizens now, I mean,
Yeah.
I know, well, yeah,
American citizens
but
and Americans
it's
still
legal
live.
now.
Right. Right.
Put it that way, they'll make it legal now.
I think that there are going to be, and it's always hard when you're predicting the future. I think that there are going to be some court tests. And, invariably, I mean, nothing is unconstitutional until somebody on the court says it's unconstitutional. I mean, we can
that
look
can
at
take
it.
years.
What's that?
That can take years.
And it can, and it can. Probably all of us know that during the Civil War, Abraham Lincoln suspended habeas.
But this isn't a suspension, it's a permanent declaration of all these powers to be arguably dictatorial given to the executive.
That
commander-in-chief.
certainly is an argument that could be made, yeah. Yeah. But, until it is tested in court, that's what you have. That's the law. And I
Because
know
our
it
Senate and
doesn't,
Congress
it
passed
doesn't seem consistent with the values that
Unless
we
you can get Obama
espouse.
to veto it.
Obama's not going to veto it. His administration asked for it to apply to American citizens because the military council, affair council actually recommended it not apply to anyone that's not in his system. The administration changed it, so it's C-SPAN.
Although the focus on those laws, I think, is less on what people say and more on what they do.
So just trusting that they'll not exercise it fully.
I know. Yeah, just believe in us, right? Yes.
But the mere
Well,
matter
and that's why,
approval
and that's
rate.
why citizens have to be vigilant, right?
What does that mean to the average American these days? To tune in and hope that you get the truth?
Well, I guess you got to talk to the average American. I hear exactly what you're saying, and believe me, I'm very sympathetic to what you're saying, and I think that's an area, those are battles that are going to be fought.
The fact is, there are no average Americans in this room. Those guys are at home watching 2
Why
men
is
a
the
baby
government
or whatever
hiring
the hell it
100,000
is.
domestic internment specialists? Why are there FEMA camps that can hold up to 1 million people?
Why are the what?
Why are there FEMA camps that can hold up to 1 million people? Why are we privatizing prison labor?
Oh, I know. I know.
These are the issues
Why
I
are
think
we-
everybody's concerned
Why,
about.
why with 5% of the world's population do we incarcerate 25% of the world's prisoners?
Yeah. Usually on drugs that we help manufacture and ship into the country and then pay our agents to launder.
Because people are making lots of money off of it.
So, yeah, there are lots of issues. To move back to the Equal Protection Clause.
That's a nice idea now.
Yeah, yeah. To move back to the Equal Protection Clause and its connection with freedom of speech. Where that came into being is because everybody was supposed to be afforded equal protection and due process. What that meant was that you could not stifle speech because of the content of the speech.
Unless it's indicative of domestic terrorism. We put clauses into our own amendments.
Yeah, I know, you can get there. In other words, the prohibitions against speaking or the prohibitions against assembly have to be content neutral. And if they're not content neutral, then that's an indication that these freedoms have been abridged, and that it's an unconstitutional restriction placed on the speech. You know, so, for example, if you're going to say it's okay to have, you know, Group A come to the park because they're going to protest in favor of fracking in eastern El Paso County, but we're not going to let Group B come and have their say because we don't like what their opinion is. That would be a violation of the 14th Amendment. So, anyway, that's been the freedom of speech thing. Let's move to freedom of assembly, which is certainly related. All right? Freedom of assembly is also connected to freedom of association. Freedom of association isn't mentioned in the First Amendment, but the courts have interpreted the First Amendment to mean that you are also free to associate with any group that you want to associate with. That was an issue during the Civil Rights era. The state of Alabama at one time wanted to outlaw the NAACP. They wanted to outlaw the NAACP, and they wanted to get their membership list of everybody who was in the NAACP. And that was kind of a scary proposition. The NAACP balked at that. The ACLU joined with them in a lawsuit, and the courts determined that association was important to the free expression of ideas, and that you could not tell people if they couldn't be a part of a particular association. And it would have, you know, to enforce that notion that you could tell people if they couldn't associate would have had a very chilling effect on freedom of speech. So those have been some of the court cases and some of the history. There's a lot more to it. You can tell we're just kind of touching the surface on some of these things. To know a little bit about where the ACLU, what the ACLU has published and provided on this, I've got these little handouts here that I'm going to pass around. There's a pamphlet that's available for you to download on the internet. It's kind of like this. I didn't print out a whole bunch of these because I didn't have that much paper, but I did print out the cover sheet with links to the locations where you can go and download this material, and a lot of the other material that I talked about tonight. You'll see that there are 3 lines there. 2 of them are to Know Your Rights pamphlets. And one of them is a Know Your Rights pamphlet that is geared specifically to Colorado. And in this pamphlet, it deals with a lot of different rights, but the ones that I wanted to focus on dealt with law enforcement and freedom of speech and assembly. And we've talked about the federal issues in freedom of speech and assembly. There is an expansion of that in the Colorado Constitution. And it's Article 2, Section 10, no law shall be passed impairing the freedom of speech. Every person shall be free to speak, write, or publish whatever he will on any subject, being responsible for all abuse of that liberty. And that was interpreted, as you pointed out, by the case involving the mall. And got something I want to share with you on that. It's an area. It was Bach versus the Westminster Mall, and this is an area that really still is open to litigation. And you know, we talked about how you don't know if something is illegal until the courts decide. You don't know if it's constitutional until the courts decide. But the background on this is that there were some folks who were wanting to distribute pamphlets and collect protest ministers in the common areas inside the mall. The mall owner would not allow it. Historically, the right to free speech had not been extended to apply to private commercial establishments under the First Amendment. And you know, we talked about the forums, and that traditionally wasn't a public forum. But the plaintiffs argued that the Colorado Constitution protected their rights to distribute literature at the mall. The Colorado Supreme Court affirmed that. And so there is somewhat broader protection given to freedom of speech in Colorado than there is just under the U.S. Constitution. And what they held was that because of the public function and public involvement regarding that particular shopping mall, such as the mall receiving tax incentives from the government, maintaining a police station within the mall, and actively encouraging government entities, such as the armed forces, to make presentations at the mall, the right to distribute political pamphlets and gather signatures was protected under the state constitution. So it's not settled whether the right to free speech that was protected in that particular shopping mall would apply to other shopping malls or other private property in Colorado. So that's something that's certainly open to interpretation by the courts. And it would probably depend on the composition of the courts and the judges that you faced.
It also depends, like the Colorado Springs Police Department had a policy of not screwing with you at all in anything remotely close to that until 60, 61, and 101 came up. And since that would directly affect the police department, they shut down as much speech as they could on that one. Because I happen to know a couple people that were doing petitions and had run-ins with the police.
Is that right?
Showed them that the court ruling, and the police weren't receptive to that anymore.
Well, you know, the hardest thing about the right to free speech is
tyranny,
enforcing it for those people with whom we disagree.
Well, that's what free speech is. It's
Yeah.
not to listen to somebody you agree with. It's
right.
to listen to somebody like from the KKK and not agree with what they say, but agree with their right to say it.
Right. Yeah. And you know, and so I know the ACLU has found itself in some pretty unpopular situations when they've, you know, advocated for people who, you know, were engaged in some pretty hateful speech. You know, the Nazis marching through Skokie, for example. And, you know, but if we're going to believe in freedom of speech, we have to believe in freedom of speech for everybody. Anyway, that's kind of the background on that case that you were talking about. Yes?
You said that was Article 2, Section 10, that was,
Article 2, Section 10 of the state constitution.
okay.
The state constitution, and the case is Bock, B-O-C-K, versus Westminster Mall.
Okay. So that, okay. That doesn't apply though to
What's that?
well, like Mark, right? Like he said, there's, until we start amending things, because doesn't Colorado Constitution also have laws that state that you can't, or Colorado have laws that state that you can't speak out against, for example, the meat industry in Colorado? You can't publicly speak or publish out any
You know,
information
I
I don't know
against
about
that.
that. I think Peter
I have heard that
Yeah.
there are laws like that.
Yeah.
Actually, I heard that said about Texas.
Yeah, Colorado has the laws as well.
But I don't know that those laws have been tested.
I see.
And you know, this is one of the things that'll happen. You'll have a law that's been passed by some sort of special interest group, all right? And they've gotten the law passed. And they will do everything they can to have that law enforced short of testing it in court,
because
Right.
it's expensive.
all right?
Yeah.
And because they don't want it to be tested in court, because they don't think that they'll win. But in the meantime, if the law is on the books, you know, they can cite it, they can write these letters to, you know, cease and desist, or whatever. They can make you so scared that you spend a lot of money on lawyers,
Right.
okay? And make you gear up for those things, and that's kind of the way they'll play the game sometimes. Anyway, this is one of the pieces that's available on the web. The other thing that I said that I wanted to share with you is some material that the ACLU has on what to do if you're stopped by the police. What to do if you think that you are engaged in something that is illegal activity, but you're facing arrest. You're facing a challenge from law enforcement. And so you get these little cards here. Pass them around. And once again, I'm not a lawyer. This isn't legal advice. These are just the recommendations that the ACLU has. A lot of them are pretty obvious. Think carefully about your words, movement, body language, emotions. Don't get into an argument with the police.
Done that before.
Step 2.
Keep your hands where the police can see them, right? Which is probably a good idea, especially if you're driving a car. I have a son-in-law who is a person of color, and he's very sensitive to that when he gets pulled over by the police. Don't run. Don't touch the police officer. Don't resist. Even if you believe that you're innocent, don't complain on the scene or tell the police that they're wrong or that you're going to file a complaint. Do not make any statements regarding the incident. Ask for a lawyer immediately upon your arrest. Remember the officer's badge and patrol car numbers if there's a patrol car there. So it'd be good to write this stuff down or talk it into your telephone or something. But try to actually write down everything that you can and record everything you can, so you don't have to rely entirely on your memory. Photographs, if you can take photographs, particularly if you suffer an injury in the process, take photographs, but seek medical attention first, obviously. And if you feel your rights have been violated, file a written complaint with the police department's internal affairs division or whatever division they have that deals with that stuff. Or you can also call the ACLU, and there's a hotline number there, a toll-free number that you can use. You also have some rights about what you tell the police and what you allow them to do. You do have to identify yourself. If they want to see your driver's license and registration, you do have to show it to them.
If you were driving.
What's that?
If you were driving.
If you're driving, yes, if you're driving. If they suspect that you are carrying a weapon, they can pat you down. But
And if you have a concealed carry permit, you should announce that immediately.
absolutely.
So if they ask to
Absolutely.
pat you down, should you ask them, do you believe I have a weapon?
I think that would be a good idea.
The search is called a Terry search. It's the U.S. Supreme Court ruling. You can read exactly what's allowed, because they're allowed to conduct a cursory search of a suspect's outer clothing. To go past that becomes a custodial search, and they cannot do that unless they've arrested you.
Right. Yeah, once you've been arrested, they can become pretty detailed in their searches.
Including snatching up your phone, whatever, flash drives, cards you got on there, whatever.
Passwords on your phone?
You also can run into questions, you've got a car, questions of whether or not they want to search your car, for example. And, probably your best bet is to always say, no, you can't search, okay? You can't search without a search warrant. Now,
Fourth Amendment.
Doesn't that go away though with the Patriot Act?
If
Can't
you're a
they?
domestic terrorist, this very big vague
Yeah, they can
term.
consider anything a domestic terrorist. I mean,
You know,
and that's
Yeah, that's
true.
true. Yeah.
That's one of the problems with the Patriot Act.
There was a case I read about a year ago, and the cops pulled the guy over and asked if they could search his vehicle. He said, absolutely not. So they sat him on the side of the road, brought the dogs in, spent 45 minutes going through his car and everything, but they didn't find anything because he didn't have anything. So then they arrested him for interfering with the police for not giving him permission. I don't know how the disposition of the case turned out. I just read about the arrest part.
Yeah.
I was like, this is wrong, just wrong.
Yeah, well, I think, with their, sometimes it depends on your jurisdiction. It depends upon what they think that they can get away with in the local district courts, the municipal or district court. What if they have a judge who is going to come down on their side. And those things, those are difficult issues. And all you can do is make some judgment calls there about, what do you think is best for you, and what personal risks are you willing to take to fight that? And only you can answer those questions. If you do have a car and you step out of the car, it's probably a good idea to lock the door and close it behind you. Because otherwise, the police officer could say, well, he left the door open, so I figured it was okay to walk in.
Same thing with your house. You step outside and talk to them, close the door behind you.
Yeah.
Like Dracula.
Right. And, you are within your rights to request to see a search warrant. And that means he has to get a search warrant. He has to
Again,
get a
doesn't that not apply though with the Patriot Act?
What's that?
Again, doesn't that not apply though with the Patriot Act, the search warrant thing? Because
The Patriot Act
they can
hasn't been
consider
thoroughly
anything,
tested.
hasn't been tested.
That's what
Yeah,
he's saying
yeah, the
about
Patriot Act has not been thoroughly tested. And I think that there are, this is just my personal opinion, I'm not an attorney, but I think that there are parts of the Patriot Act that would not survive that kind of judicial inspection.
How can you,
I can hope, anyway.
how can you oppose the provisions of that in a judicial court if you're not allowed your day in court?
Well, you can't. That's,
How are we ever gonna
that's
test it?
exactly, that's the problem.
So the Second Amendment is about,
So that's true. That's, although, you know, there are other ways of approaching it. You know, outside the courts, ways of approaching it would include trying to approach it through legislation as well.
yeah, but if you're locked away in Guantanamo Bay, you're not writing a letter to your senator.
That's right. That's right. But there are organizations that can lobby on your behalf.
They know about it.
Right. But, I mean, you have to keep in mind, not everybody voted for the Patriot Act.
No, just the majority of them.
Right.
That's all it takes.
I know. And, you know, so that becomes a part of the public debate. And to a certain extent, you know, the fundamental right here is the right of freedom of speech and the right that we all have to try to convince the majority of our fellow citizens that what you see as an injustice is in fact an injustice. It's hard to do. Yeah.
And you said, like you said, you have the right to request to see a search warrant, correct?
Right.
Now, if you stand in front of, whether you're in front of the car or whether it's your house, and you lock the door and you do not allow them to enter until you see that search warrant, can they later, kind of like what I guess, like similar to what you was talking about, can they later charge you with obstruction if they do, in fact, are able to produce it later,
No.
but they could not produce it at that very moment?
No. No.
Okay.
No.
Mind you, they can charge you with whatever they want. It's how it
Whether
is
you're
done for
convicted or
later.
not is a
A lot of times, district attorney will just throw as many as they can at you, so
So you plead down, right?
because there's a profit motive behind people's freedom in private
The
incarceration.
That's
the
right.
profit motive works the other way too. When you demand a full trial by jury and think you're gonna take a weak argument on your point, they don't want that. Because it costs them a lot of money to run a courthouse. It really kind of depends.
But you
if
pay
sound
court fees.
Intelligent. You don't pay near what it costs them.
Yeah,
And
possibly.
it depends if you kind of sound like you know what you're talking about when you talk to the DA, because you always do before it goes.
Right.
Because I had one case kicked like that. And I was in Salida, Chaffey County, and said, the first thing I'm going to do is go to Denver and hire a lawyer. Because the lawyers in the same town, they always sit and have lunch with each other
Yeah.
and make deals and wheel and deal. When you go someplace else and hire a lawyer who's got nothing to lose coming down there, they look at it a lot differently.
That's why they say to have a lawyer in town for a traffic violation, because they can usually get it dropped, but nothing more serious.
Yes.
And
So-
I'm not a lawyer either, so I had some experience.
Anyway, this is about what I prepared to share with you folks for tonight. And I'd be, you know, glad to talk about things a little bit more. Once again, I'm not an expert, I'm just sharing material that the ACLU has produced.
What's the role of the ACLU? I've gotten the impression, one, that it could advocate for our rights, but tonight I've gotten the impression that it's about telling people how to steer clear of getting in trouble, so kind of understanding that their rights are limited. So what's the role that ACLU plays, and in particular with the occupation movement?
Well, this is our mission. It is to protect, defend, and extend the civil rights and civil liberties of all people in Colorado through litigation, education, and advocacy. And really what this is part of the education mission, in terms of like coming out here and letting you know what material we have. In terms of litigation and advocacy, the ACLU does engage in what it considers to be court cases that have significant constitutional issues attached to them. I know that in Colorado Springs, one of the cases that that they worked with involved Palmer High School and the treatment that one of the clubs, it was LGBT club of students. And the school was discriminating against them, and the ACLU entered into that controversy on the side of the students and eventually prevailed. Recently, the ACLU engaged in a case up in Castle Rock that involved the use of school vouchers. That is, vouchers that would transfer money that otherwise would have gone to the public schools and giving to the private schools. And the ACLU prevailed in that case. There have been other cases in Colorado, and I can't give you a whole listing of it, but they do work through litigation. I know that I don't think that they've done anything with Colorado Springs Occupied Group that I'm aware of.
Is David Lane, an ACLU attorney that's handling things in Denver, does anybody know?
David Lane has been involved with them, yeah.
So he was assigned by the ACLU for Occupied.
He's not an ACLU attorney, but
he's on the list of
he's on the list.
rotating.
Yeah, that's right, that's right. And I think he gives some of his time to the ACLU. Right. And so, I know that he's been involved with Occupy Denver.
Right.
And some of the legal issues that have come up with Occupy Denver. And the ACLU is, in a way, it kind of makes, it's understandable that they would be associated more with what was going on in Denver because their offices are downtown in Denver. They're probably within walking distance of Lincoln Park.
Yep.
But have they actually litigated anything for Occupy Denver? Because I know David Lane was seeking an injunction and he didn't get that, but I don't think that was driven by the ACLU.
I don't think that anything at this point has been and yeah.
What there was, I forgot her first name. Her last name's Rich. Rich is her last name with the ACLU, Denver ACLU. That did write a letter to the court because they had tried to tell the occupiers and even the press that they could not take any recording devices, and on top of that, they couldn't even have pencil and paper. And
I know, they were scratching with their fingernails.
And so they ended
paper.
up, and I do know that like one of the attorneys from the ACLU did write a letter demanding that not be upheld and that situation be taken care of immediately on that part. That was like at the middle of November. I think November 16th is when she had wrote that. I don't remember her first name. Her last name was Rich.
Yeah, I know. That was an area of concern, and a lot of times with the way the timeline kind of works is that the first thing, if the ACLU is getting involved, the first thing that they might do is write a letter.
Right.
And which just kind of puts people on notice. Okay, we're kind of interested in this. We think there's something here that's not quite right, and they'll write a letter. And then the next step might be filing some kind of an injunction.
So they would possibly go ahead further with that.
And eventually they might go further. But it's kind of a metered sort of response to those things. Oh, I just remembered another ACLU activity involving El Paso County, and that dealt with the county jails not allowing inmates to write letters. They required the inmates to just write a postcard. Wouldn't let them write a letter that they put in an
index card. Go to a senator.
Yeah, it was like an index card. Yeah. And the ACLU thought that was an unconscionable limitation on the freedom of speech.
And that was, they wrote a letter about that. They didn't have to challenge anything in court. It was just the threat of the challenge.
It was the threat of the challenge that did. And that's why I kind of made the point here that it is kind of a metered response. You're going to start out with something like a letter, and eventually it might go further. And there were 2 counties that were doing that. And this is interesting. The 2 counties in the state that were involved in restricting inmates' freedom of expression or ability to write the letters, El Paso County and Boulder County.
Literally.
There's the range.
I have a point on the Patriot Act, and you're right, you have to actually get into court before you can make a lot of these points. But there's another right that, to quote Justice John Jay, the first Chief Justice of the U.S. Supreme Court, it is absolutely the right of the citizen jurist to judge both the facts and the law in controversy. So you can decide that, hey, this law is unconstitutional as a jurist and not convict.
Jury nullification, you need to know about that. If it's an unjust law.
For that practice.
Yeah, but
Wasn't it Creel was there?
you don't have to tell them why you vote that way. So if you ever
Wanna
find
watch,
yourself
like-
on a jury, think that.
Oh,
And another thing, when they put you on a jury, they give you a notebook for you to take notes in. They give it to you so that they own that notebook. So you can't take it with you. Just keep that in mind.
So what do they do with those notebooks?
They take them up when you're through your jury duty.
I'm not sure exactly.
Yeah, but then what?
I
Put it in the
can't-
case
Well,
file. What else?
then nothing if you're smart enough to tear out the pages that you wrote your notes on and
Give
take
it to
them
the
off.
prosecutor so he knows next time how to better report a case.
Probably.
So take your own notebook.
Yeah.
So,
An interesting case in El Paso County that people should pay attention to right now is the case of Bob Kraus. He's a 63-year-old guy with leukemia who's being thrown into prison for having his medical marijuana rights and growing his own plants for that, which is guaranteed under the Colorado Constitution, Article 3, Section B of the 20th Amendment in Colorado Constitution. So whether or not that's going to be upheld, and is that something that maybe ACLU would assist with? Because he's, I don't know, it just seems very wrong in a lot of ways to.
yeah, it might be, I don't know. I can't speak for that.
Well, the federal illegality of cannabis itself shouldn't prevent states' rights from existing. This is the 10th Amendment argument. If we create something under our Constitution, we as a people, right?
Well, I would assume that he's being in prison, he's being charged under some sort of state law, right?
Correct. The idea that, well, the state law that's being charged against is really not a case in the first place, because the district attorney just doesn't read the law. So, because there's over 6 plants, this whole idea in law enforcement right now, because the law is so new, is that 6 plants is the limit. If you're written a recommendation for 75, say for example from your doctor because you're producing edibles or some sort of other medication, that's sanctioned now by the state departments that take that application paperwork. In fact, it's on the form for that state department, but this is a nuance that our district attorney down here doesn't get because he's apparently overzealous enough to prosecute 63-year-old guys with cancer.
He takes all of his medication.
Right.
The national ACLU has declared that one of its points of interest, its vectors of interest, it has to do with drug laws. So they have that's on the national website. That's national in Washington D.C. So I guess that raises a question for me. How can citizens or even ACLU members petition the Denver office about what cases to take and what directions to go?
Colorado's setting precedents for a lot of marijuana laws, right?
Well, they have a form you can fill out on their website.
What's that?
They have a form you can fill out on their website to request exactly
I
that.
guess my question is, how can they? I mean, I know it's a kind of a round table of lawyers who will discuss a case and decide whether to take it on. And how can somebody bring some pressure to bear to say, hey, come on, you guys, please try to support this.
I think it would be in contact.
Right.
I think it would be in contacting them. And one of the other things that is particularly interesting is something that I learned really last spring at the annual state membership meeting of the ACLU. And that is that Colorado is one of the target states, right, for the national ACLU. There are a lot of things going on in this.
We're a big swing state, always.
And so I think that if you if enough people make noise about it to the ACLU, you have a better chance of us getting attention.
And it doesn't have to be through the legal system. He's a politically elected person, targeting them.
Yeah, Dan May, by the way, is up for re-election next year. Don't vote for him.
Yeah, but targeting, go to his event, have
Well,
signs, raise hell.
That's what we do every time Bob has a court date. We get over 60 people out there to protest on his behalf, but when your local government's so involved with local media that they won't even cover those issues, it's how do you spread that message? And you probably have to send it up to the
Activist
ACLU.
media, like that guy.
That's true.
ACLU can't do any
political
political advocacy. I mean, it can't actually advocate for, you know, one candidate over another. It's completely limited in that way. It's got to act through the courts.
But
or
this group isn't. This group can act against Dan May.
Yeah, absolutely. I mean, you could recall election your politicians. It takes 25% of the votes that it took to get them in office in the first place. And if you call, they start forwarding up to their managers because nobody knows what the procedures are to do it because it's been so long since we, the people, have enacted those rights to get rid of the people that are causing problems. Another one's John Surthers, who used to be the district attorney down here back in like the 70s and 80s. And Dan May was his deputy district attorney. So you see that like all of this stuff just runs in the same cycle for 20 plus years, the same guys making the same policies. And John Suthers right now is going around the state into places that don't have medical marijuana and telling them that it's going to screw up their teenagers. I mean, this is what he's doing and saying that it's all 20, 30-year-olds using the system when the statistics have consistently been 40 years old plus. So I mean, it's this complete lying and propaganda that I've seen, at least in the work that I do, that would want me to recall both of these guys, or at least do as much as possible not to re-elect either of them next year. It's crazy.
Yeah, well, in further disclosure, I have, and I'm not speaking for the ACLU now, but just for myself personally.
Yeah.
I have a son who's spending 31 years in prison for a crime that he didn't commit, thanks to the local DA's office.
Gosh.
And so.
Well, they want to throw old men in prison to die without medical cannabis to help alleviate their suffering.
Yeah, and then, you know, Colorado has a higher incarceration rate than the average.
And a higher recidivism rate too.
And, well, they go together. They go together. And it's not necessarily getting any better.
No. And the number one reason we lock people up is over nonviolent drug offenses. It's kind of crazy. Sorry. I mean, that's a big, serious issue we could actually change, guys. Especially being double the size of the baby boomer generation. Most people in here are a little bit younger. I mean, it's a real issue that could change, and Colorado has a real chance to be the first state to do it next year. Yeah, at least for cannabis, which is the biggest problem, right?
There's me also. I have court on Monday for setting up some tables and having some food and some information handout for the City Hall. And they didn't like that very much and said that I was in violation of 3-2-201, permits required, subject directed tables and stored property on public property. Well, how did they know whether or not I was going to store it there? I was just there handing out some information that day because they told me I couldn't be in the park. They didn't know if I was going to store it there.
Were you on the sidewalk?
I was in the grass because they told me on the sidewalk was 3-2-217.
Yeah, it was a different warning. It was a different ticket.
And it was part of a protest, and you know, the freedom to assemble and to protest. It wasn't about setting up a private picnic. It was a protest. It had protest banners and signs, and it was protesting in front of City Hall. Nick, have you contacted the ACLU about support
No, I hadn't even thought about that. No.
Right.
Right, the NLG, you know, you can connect just those guys, and, you know, they got all of the lawyer in town for me, I can certainly, if you your email.
And that's the National Lawyers Guild.
Yeah.
Right, so, and the National Lawyers Guild has been taking the cases of all the Denver occupiers, so apparently the ACLU is getting a free ride on that and being able to say, and the National Lawyers Guild will take care of it.
Court.
So, but I mean, is it worthwhile to try to push Mark and to see, hey, you know, can you support this? Yeah,
I don't think it would hurt to ask.
yeah, we have to ask.
I was just wondering, 'cause I thought that was a little odd.
You know, I saw on the news tonight a similar, and I'm trying to remember which city it was in. I'm thinking that it might have been in,
There's cannabis in prison, that's an old law.
might have been in San Diego, Occupy San Diego, where the specific issue that they were involved in involved setting up tables. They were registering people to vote. And they were told, you can register people to vote, but you can't have a table. But eventually the police backed down and let them do it. But that was in San Diego. So it's an issue that's come up, not just here, but elsewhere.
Yeah, the other thing about my arrest is I was never read any rights, and I think that was just because it was a ticket in the lease, I didn't remember something like that. I never read any rights. And the arresting officer, the lady who actually took me down to the police station, I kept asking her, you know, what's the charge? What am I charged with? Well, I don't know. Well, I don't know. You know, I didn't know until the lieutenant managed to make his way down there, and the lieutenant actually had to go look up what it was that the city attorney told me to charge me with. Wow. And I was not warned with the second code violation. The first violation was public right-of-way, so I moved to the grass. He waits for the city attorney to call, gets off the phone and says, whose property is this? Well, I say, well, it's mine. And, you know, I look right at him and go, you know, mine, as in occupied. It's yours, it's theirs, it's everybody's. And he said, well, you need to come with me and give this officer your information. I was like, well, I don't want to give you any information. Why am I being singled out? And that's when he placed me under arrest. And then I asked him, you know, what for? Well, I don't know. What do you mean you don't know? And then everybody else started chanting, of course, what's the charge? What's the charge? Because I heard the officer go, I don't know. We had 6 different officers on camera going, we don't know. We don't know. And as far as I know, they're supposed to tell me as I'm being arrested.
They better know what they're arresting you for.
Some idea, you're under arrest for blah, 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 and we're going down to the police station. But I didn't even know until I was already at the police station. Been sitting there for like 10 minutes waiting for the lieutenant to get there.
For them to warrant the reason they arrested him.
Yeah, so they could figure out why they didn't arrest me.
They had to come up with some bullshit.
Pretty much. He had to actually pull the book out of the ordinances and go, oh, that's what they were talking about.
You can't have personal
He didn't even know why
property
they
on
were
public grounds.
So I didn't know if that was
That's what they
anything else
charged him with.
You're supposed to go.
That's what they said.
Violation of things they were
That's
supposed
what
to
the
do.
ticket says.
My rights, tell me
You
what
can't
I'm
have
charged
personal
with,
property
I
on
asked,
public
but-
grounds.
So they never.
So we should start telling them to
And it's
arrest
on the-
everyone who
I'll ask for
lays it
the-
down in the grass.
Then you
Then you can't have picnic
Oh, she
anymore.
asked me for my,
Yeah,
she asked me for my
under
name,
public.
and at first I told her, well, you have my wallet, you can find my name
Literally,
there.
that's what it
So I
says.
told her,
Your wallet in your pocket.
And then I said, well, with the Patriot Act, I might as well just tell you my name, because then if for some reason my license isn't in there, you can hold me as long as you please, and then you can figure it out. So I decided, I went ahead and told her my name, and then I just waited until I talked to Rigdon, and then after I figured out what the ticket was for, I just, you know, had a casual conversation with them. They weren't asking questions as to, what are we doing, why are you here? Well, yeah, I kept asking her, you know, what am I being charged with? You know, I don't know. What? You don't know? You should have let me go then, because
Well,
pretty sure they're supposed
the
to tell me.
lieutenant, yeah, that was
Arrest.
messed up. And the lieutenant though told me later on that the reason that he basically had just told the other officer that was there, the lieutenant had just gotten off the phone with the city attorney. He just told the other officer to go ahead and take him in. And he said because he felt that the situation had escalated and that the officers had become endangered. And that's why they had to immediately get him in the car and leave. When there was probably more officers there than there was of us, wasn't there, if I remember right? Like, there wasn't very many of us there, and there was more officers than us, but they said they were in danger, and that's why they had, their first course of action was to get him in the car and get away from the scene.
Sounds like the city attorney was calling shots.
Well, yeah, Chris Melcher, they called him, and that's what they was waiting on the whole time. And then that's
Really
why,
means the mayor was calling the shots.
right, yeah.
Well, the mayor and the city attorney are hand in hand.
Well, he is actually his boss. Now, under new strong mayor, we have a different form of government, which I actually even emailed everybody. I'm going to print it out and put it on my office, but new executive form of our mayor's government. So that's all different now too, but the city attorney's directly under him, chief of police, fire, so it's just a small presidency.
One thing I've always been curious about, speaking of permits, How do groups like the KKK get permits to be able to use speakers, megaphones, all that? Police protect them, they set up barricades to
Because they
protect them.
get a permit.
But why can they get a permit but not the occupiers?
Yeah,
What loopholes do they use?
You could, but only for 30 days, and then all of a sudden you don't have the First Amendment anymore. That would be sanctioned by the city.
Because the state supports what they say. The state is in favor of the things they say.
Because we live in a police
They don't
state.
threaten the state.
We don't wear clean white hats.
We're not a time-honored tradition.
It's not a national pastime.
I thought I got away from that moving out of Tennessee.
All right, guys, let's give Bill a round of applause. Thanks everybody for coming out tonight. Tuesday night, we've got another one. We'll be over at Cafe Corto, 8:30. Lauren's gonna talk about Post-Patriot Act and fusion centers. Should be very interesting. So make sure you guys stop over there. If you guys want, I've got the next 3 educational seminars printed out and dates. If you guys need a flyer, I have one for you.
Real quick too.
Over there at the cafe court.
The way we're gonna line it up, because we're actually gonna do chairs in there for when he comes in. They got 40 Avon women in there. So we'll be okay as long as we line the chairs up right.
I just wanted to ask real quick, because I know Mark had brought up about the 1867, the Bill 1867 and stuff. They are putting a call of action out for anybody and everybody, all the occupations, to actually stand in solidarity, because they're going to go to the Senate, your local senator's building and occupy your senator's building on December 14th. So if that's something like we could, and just so everybody knows, both Bennett and I forgot his name, starts with a U.
Don't go.
Yeah, Udall. Both of them did actually vote for the act. So yeah,
All of our
if we want, if
senators
everybody
are-
wants to think of what we can do on that day on December 14th to show them we're not happy with how they voted.
Are you sure? I think you'd all voted against it. You was part of the
No,
38,
no,
wasn't
no.
No.
It was 97 versus 3, and they both voted for.
it? Was
Now,
Rand
he
Paul one of the
presented-
3?
Udall was the one who
No,
put
Rand
the-
Paul held out.
Right on the 38 on the congressional. It
Yeah.
was only 3 that
do
didn't.
is they
Yeah.
definitely suspend the
Go do it.
purpose. How would we ever have to fight that back in court?
See, what are the staffers gonna say to their bosses, like when you have 20 people who refuse to leave, and it's happening everywhere?
Well, that's what I'm saying.
But that's what's causing the fear that's making these guys pass kind of shit like this, because they think that country's going out of control based on the minority, and those people can easily be declared domestic terrorists, turn into prison laborers, and end of story. That's like problem solved. Of course. I agree with you. The only things going through Congress are regulation of the internet, which is our last freedom of speech. Burn that up. Now we can control everything we do through an IP, period. And then it's to shred the last bit of habeas corpus.
There's a set of keys over here too, so they don't end up in the wrong purse.
That's why I was like, whoa.
No.